Foreign high net worth individuals frequently ask whether trusts or private foundations are recognized under Vietnamese law. In common law jurisdictions, trusts are central to estate planning and asset protection. In Vietnam, the answer requires careful distinction. Vietnam operates under a civil law system. The concept of a trust as understood in common law does not exist as a standalone legal structure under Vietnamese domestic law. This structural difference is fundamental. Vietnamese law does not provide for private family trusts in the common law sense. While civil law mechanisms such as agency or asset management contracts exist, Vietnamese legislation does not recognize a separation between legal and beneficial ownership as understood in trust jurisdictions. This structural difference has direct implications for estate planning. Although Vietnam does not have a domestic trust regime, trusts validly established under foreign law may still exist as legal relationships governed by that foreign jurisdiction. The question in Vietnam is not whether the trust exists abroad, but whether and to what extent its legal effects will be recognized domestically. Vietnam has not adopted the Hague Trust Convention. As a result, recognition of foreign trusts is not governed by an international uniform framework. Each case depends on conflict of law analysis and the nature of the underlying assets. A movable property located in Vietnam is governed by Vietnamese land law. Land use rights must be registered in the name of a legally recognized individual or entity. Vietnamese law does not operate on a system of split legal and equitable title in land registration. Registration status is decisive in determining enforceable ownership. If a foreign trust asserts beneficial ownership over property in Vietnam, Vietnamese authorities will primarily recognize the registered legal owner. The internal trust relationship may remain valid under foreign law, but it may not have automatic effect against third parties or land authorities in Vietnam. Registration formalities prevail in determining enforceable rights. For movable assets such as shares in a Vietnamese company, recognition analysis becomes more nuanced. Vietnamese corporate law recognizes registered shareholders. Beneficial ownership through a trust may not automatically control governance rights. Private foundations established in civil law jurisdictions such as Liechtenstein or Panama may exist as separate legal entities. Vietnam may recognize the foundation as a foreign legal entity. However, asset ownership and regulatory compliance must still align with Vietnamese law. If a foreign trust or foundation seeks to hold equity in Vietnamese companies, foreign investment regulations apply. Licensing, sector restrictions, and reporting obligations remain decisive. Structure does not override regulatory compliance. Trust and foundation structures may create cross-border tax implications. Vietnamese tax authorities focus on legal ownership and income realization within Vietnam. Transparency and reporting obligations cannot be bypassed through structure alone. In inheritance or asset disputes, Vietnamese courts will apply domestic mandatory rules first. Trust deeds governed by foreign law may be recognized as contractual arrangements, but their effects cannot override compulsory heirship protections, land registration requirements, or foreign ownership restrictions under Vietnamese law. Where assets located in Vietnam are involved, Vietnamese compulsory heirship rules remain applicable to the portion governed by domestic law. A foreign trust structure does not automatically exclude protected heirs from asserting statutory entitlements over assets subject to Vietnamese inheritance rules. Public policy considerations remain central. Despite these limitations, trusts and foundations may still serve strategic purposes. They can centralize ownership outside Vietnam. They may facilitate succession planning in jurisdictions where they are fully recognized. Many foreign investors prefer corporate holding structures rather than trusts for Vietnamese investments. Corporate entities are clearly recognized under Vietnamese law. This often provides greater operational predictability. If a foreign trust or foundation is used, its terms must align with Vietnamese corporate, land, and inheritance law. Misalignment creates litigation and enforcement risk. Coordination across jurisdictions is essential. Foreign estate planning techniques cannot simply be imported into Vietnam without adjustment. Legal concepts travel imperfectly across systems. Local compliance determines practical effectiveness. For high net worth individuals with assets in Vietnam, estate planning should combine foreign structures with Vietnamese legal review. This includes assessing forced heirship exposure, property registration, and corporate governance. Holistic coordination is decisive. Vietnamese law prioritizes statutory ownership registration, family protection principles, and regulatory compliance. Any trust or foundation structure must operate within these boundaries. Substance prevails over label. Trusts and private foundations are not domestically established structures under Vietnamese law. Foreign trusts may be recognized in limited contexts but not automatically enforced as in common law jurisdictions. For foreign investors and multinational families, estate planning involving Vietnam requires adaptation, not assumption. Structure must follow jurisdictional reality. If your estate plan involves trusts or private foundations while holding assets in Vietnam, structure alone is not sufficient. Recognition depends on how foreign legal concepts interact with Vietnamese land law, corporate regulation, and compulsory heirship principles. To assess whether your trust or foundation structure will operate effectively within Vietnam's civil law framework, contact LTS Law at lts.com.vn for a coordinated cross-border review. In international estate planning, recognition is contextual. Structure must adapt to jurisdictional reality.